Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 27 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering 2 weeks' worth of cases as we took a break for Christmas. This week we are covering cases decided between December 16th, 2020 and December 29th, 2020. We will start this week with the case of Commonwealth versus Alexander. This case marks a significant change in the law regarding the automobile exception to the general warrant requirement. The case is an interesting read through the history of the vehicle exception and the difference between the Fourth Amendment of the United States Constitution and Article 1, Section 8 of the Pennsylvania Constitution. For a history lesson, you should read the case as it is an interesting read, but for purposes of today's podcast, I'm going to cut to the chase. This case stands for the proposition that Article 1, Section 8 of the Pennsylvania Constitution carries with it greater protections than the Fourth Amendment and specifically overturns the prior plurality opinion of Commonwealth v. Gary and returns to the limited automobile exception, pursuant to which warrantless vehicle searches require both probable cause and exigent circumstances. One without the other is insufficient. The dual requirement of probable cause and exigency is established part of state constitutional jurisprudence. The court states that police officers are eminently capable as trained professionals of making the basic assessment of whether it is reasonably practicable for them to seek a warrant under all of the circumstances existing at the time they wish to search an automobile. The basic formulation of exigencies recognizes that in some circumstances, the exigencies of the situation make the need of law enforcement so compelling that the warrantless search is objectively reasonable. That inquiry, however, is not amenable to a per se rule and requires a consideration of the totality of the circumstances. Going forward, obtaining a warrant is the default rule. If an officer proceeds to conduct a warrantless search, a reviewing court will be required to determine whether exigent circumstances existed to justify the officer's judgment that obtaining a warrant was not reasonably practicable. That the universe of qualifying exigent circumstances is impossible to find with precision does not justify adopting the federal automobile exception any more than the inability to supply an objective definition of whether an expectation of privacy is reasonable justifies jettisoning the Fourth Amendment. Courts will have to decide whether exigent circumstances justified warrantless searches in discrete scenarios with a focus on the particular facts. The bottom line of the case is this. The court does not care if this makes the job of a police officer more difficult. They trust officers are trained sufficiently to determine whether their circumstances justify a warrantless search. The court declines to delineate a bright-line rule of what constitutes exigent circumstances and finds that it will be the burden of the courts to establish this on a case-by-case basis. In the case of Commonwealth v. Smith, the court addresses timeliness of a PCRA petition. In the typical case, a PCRA petition is filed too late and the petitioner is trying to find an exception to the 1-year time bar. However, in this case, the petition was filed too early. Here, the defendant lost at trial and filed a timely appeal. His appeal was denied, and he then appealed to the Supreme Court. While the matter was still pending before the Supreme Court, he filed this PCRA petition pro se. However, under the law, a PCRA petition may not be filed until the judgment of sentence has become final. This includes all levels of appeal, including discretionary review. Because the case was still pending before the Supreme Court, the PCRA was premature. Though the PCRA court accepted the filing and eventually dismissed the case, the Superior Court finds that they are without jurisdiction to address any of the underlying claims as the petition was untimely and the PCRA court had no authority to rule on it in the first place. It is important to remember in cases like this that rules about when to file are extremely important. If you have legitimate issues but the petition is not filed at the right time, you may forever lose the ability to argue the merits of your case. This is one of the many reasons it's so important to have a lawyer who understands deadlines and court rules and proceedings. In Commonwealth v. Carlson, the defendant was charged with aggravated assault and related crimes following a domestic incident. He was appointed a public defender who represented him at the preliminary hearing and for a significant portion of the case at the trial level. At some point, the defendant got a new job and his public defender filed a motion to withdraw his counsel, stating that the defendant's new income disqualified him from representation by appointed counsel. The defendant stated that he wanted his attorney to continue representation, but the court granted the public defender's motion to withdraw without even having an evidentiary hearing. The defendant requested several continuances to obtain counsel and was unable to do so in part because he broke his arm and required surgery, and in part because he was not making enough money to meet all of his financial obligations and pay for a lawyer. The court ultimately required that he go to trial pro se. The defendant said almost nothing at his trial, claiming that he did not want to speak without a lawyer. He was convicted and ultimately appealed. The Superior Court found that the trial court violated his Sixth Amendment right to counsel by failing to conduct an evidentiary hearing to determine if he was able to obtain an attorney. While indigency is one factor to consider, it is not the only factor. The court has the ability to appoint counsel if it is in the interest of justice to do so, and the Superior Court found that the court was unable to make that determination because they held no hearing. The judgment of sentence is vacated and the case is remanded. The trial court is directed to conduct a full evidentiary hearing if appointed counsel is requested by the defendant to determine his eligibility. If the court finds him ineligible, they must state the precise reasons why on the record. In the case of Commonwealth v. Donoughe, the defendant was arrested for a first offense DUI. He was initially admitted into the ARD program. Approximately 7 months later, he was removed from ARD for failure to comply with the required conditions. He opted to take the case to trial and requested his discovery, including the officer's dash camera footage. The Commonwealth responded that the dash camera had been destroyed, consistent with Pennsylvania State Police official policy 5 months after the defendant had entered the ARD program. The defendant filed a motion to dismiss for a Brady violation. The judge denied that motion, and after conviction at trial, the defendant appealed. In order to succeed on a Brady claim, the defendant must establish that the evidence was exculpatory. If unable to establish that the evidence was exculpatory, the defendant must show that the evidence was potentially useful and destroyed in bad faith. The defendant was unable to establish by any evidence that the footage was exculpatory, and therefore the potentially useful bad faith test must be shown. There was no evidence presented to suggest bad faith. In fact, the record was clear that there was no bad faith and that the officers were simply following protocol. The Superior Court found no abuse of discretion in denying the defendant's motion to dismiss, and the judgment is affirmed. In the case of Commonwealth v. Floyd, the defendant was charged with numerous crimes, including possession with intent to deliver. He was initially represented by the public defender, but requested that the public defender no longer represent him and that he wished to proceed pro se. He filed a pro se motion to suppress. At the hearing, he represented himself with the public defender appearing as standby counsel. At the hearing, the court did not conduct a waiver of counsel colloquy. The defendant eventually appeared pro se and entered a guilty plea, where again the public defender appeared as standby counsel. At the guilty plea, there was also no waiver of counsel colloquy, and the defendant was not advised of his appellate rights. When a defendant seeks to waive the right to counsel, the trial court must conduct on the record a full and complete waiver colloquy to determine whether the defendant's waiver is knowing, voluntary, and intelligent. The court must conduct a thorough inquiry into the accused's appreciation of both the right to counsel and the right to represent oneself at trial, guilty plea hearings, sentencing, and every critical stage of a criminal proceeding. A court's failure to conduct a valid colloquy before allowing a defendant to proceed pro se constitutes reversible error. Additionally, where the court fails to conduct a waiver of counsel colloquy, a defendant's alleged waiver of counsel is ineffective, even if the court has appointed counsel to stand by. Here, because the court failed to conduct a waiver of counsel colloquy, the guilty pleas are vacated and the judgment of sentence is vacated. Commonwealth v. Sami is a discussion of relevant evidence and evaluating probative value against prejudice. In this case, the defendant was arrested after being found in a residence with 2 deceased women and admitting to their murders. At the time, she claimed that she was a marijuana user, but it was not suspected that she was under the influence of anything, and no toxicology was done to determine if she had any intoxicants in her system. Defense investigators had also spoken with her family members who opined that she may have used other drugs besides marijuana and that some drug paraphernalia was found in her home. The defendant filed a notice of insanity defense, claiming that her diagnosis of delusional disorder and intense paranoia at the time significantly compromised her ability to understand the nature and wrongfulness of her actions. In response to her insanity defense, the Commonwealth filed an expert report that claimed her delusions were caused by voluntary intoxication due to ingestion of marijuana and other drugs. Defense counsel requested that the portion of the Commonwealth's expert report relating to other drugs should be stricken. The court granted the defense motion and the Commonwealth appealed, certifying that the court order substantially handicapped their ability to prosecute the case. The rules of evidence state that all relevant evidence is admissible and that evidence that is not relevant is not admissible. Further, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. However, the court can exclude relevant evidence if its probative value is outweighed by danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. In this case, the court found that the evidence of defendant's prior drug use is relevant to rebut an insanity defense to murder charges by showing that the defendant's mental illness was drug-induced psychosis. Nevertheless, in this case, the Commonwealth has not shown that the disputed evidence of the defendant's alleged use of methamphetamine and cocaine is relevant, such that it logically tends to establish a material fact in the case, tends to make a fact at issue more or less probable, or supports a reasonable inference or presumption regarding a material fact. Moreover, the prosecution failed to establish a close factual nexus sufficient to demonstrate the connective relevance between her possible possession of drugs to the crimes in question. The Commonwealth has not presented any evidence to show that the defendant ingested these drugs on or around the time of the crime. The only evidence that drugs existed consists of the statements of the defendant's family members concerning items they observed in her bedroom. The court finds that the probative value of this evidence is outweighed by the potential for prejudice to the defense. Allowing the prosecution to admit speculative evidence of the defendant's possible drug use that lacked a factual nexus to the murder charge would have the potential to confuse the jury or to result in unfair prejudice in suggesting a decision on an improper basis, or to divert the jury's attention away from its duty of weighing the evidence impartially. The court consolidated the appeals of Davis and Lehman as both present the question of who is responsible for the cost of prosecution when resentencing is required. In both cases, the defendant was convicted of first-degree murder as a juvenile and sentenced to life in prison without the possibility of parole. Both sentences were overturned and resentencing was required. The Supreme Court answers two questions: whether trial courts may impose the cost of sentence upon criminal defendants generally, and if so, whether the cost of resentencing may be imposed upon those whose original sentences were vacated due to their original sentences being found unconstitutional. The law allows the Commonwealth to recover all necessary expenses incurred in investigating, apprehending, and prosecuting a criminal defendant. Further, in any case where a defendant is convicted and sentenced to pay the cost of prosecution, the expenses of the district attorney shall be considered a part of the cost of the case. The court must determine whether costs associated with resentencing are necessary. The term necessary is defined as absolutely needed or of an inevitable nature. The court finds that per the rules of statutory construction, the law which authorizes costs of prosecution, which is penal in nature, must be strictly construed in light most favorable to the defendant. In answering the first question, imposing costs of sentencing on defendants in the first instance was proper, as they were an inevitable and expected consequence once prosecution resulted in a conviction, and therefore a necessary expense. In regard to the resentencing, the court finds that the hearing was not necessitated by the defendant's own actions, but rather by a change in the law. The court concludes that because the defendant's own actions did not cause the resentencing, the costs associated were not connected with the original prosecution, and therefore the cost cannot be charged to the defendants. In the case of Commonwealth v. Peck, the defendant sold drugs to the victim. The transaction occurred in Maryland. The victim later returned to Pennsylvania, where his ingestion of the drugs resulted in his death. The defendant was charged with and convicted of drug delivery resulting in death. He appealed on the grounds that because the delivery occurred in Maryland, he could not be convicted in Pennsylvania. The court finds that the language of the statute is clear and unambiguous. When the defendant administers, dispenses, delivers, or gives a controlled substance, he must do so in violation of Section 780-113 of the Drug Act. In order to meet the elements of 780-113, the delivery must occur within the Commonwealth of Pennsylvania. So while the law provides jurisdiction to prosecute because the death occurred in Pennsylvania, they were unable to produce sufficient evidence to establish the elements of drug delivery resulting in death because they cannot establish that the delivery occurred in the Commonwealth. In Commonwealth v. Lambert, the defendant was arrested following a report of domestic violence. At the time of the arrest, the victim made an oral statement and provided a written statement of what happened. At the preliminary hearing, the Commonwealth presented the statement of the victim, but the victim did not appear to testify. The changes were held for court and the defendant filed a petition for habeas corpus. A habeas petition is used to establish a prima facie case when the case is at the common pleas level. In general, the trial court can rely on the record from the preliminary hearing in determining whether prima facie was established. However, in this case, there was no record made of the preliminary hearing. At the habeas hearing, the Commonwealth presented no evidence. The trial court judge dismissed the case for failure to establish a prima facie case. The Commonwealth appealed. The Superior Court found that there was no error. A habeas petition was proper, and it was the Commonwealth's failure to present evidence that resulted in the dismissal. The order of the trial court is affirmed. We will finish the week with several cases that were decided that factually aren't that interesting. For brevity's sake, these cases are addressed minimally, but I will address the rule of court in each case. Commonwealth v. Leone supports previous case law finding that the lifetime registration requirements of SORNA are not punitive when a sexually violent predator determination is made, and therefore a defendant who is found to be an SVP is not entitled to any relief for SORNA registration requirements. Commonwealth versus Reslink is another case addressing the applicability of SORNA. However, the defendant failed to object at the time of sentencing and failed to file a post-sentence motion. The questions were raised for the first time on appeal, and it is well established that if an issue is raised for the first time on appeal, the issue is waived. In Commonwealth versus Asher, the court again addresses the constitutionality of SORNA registration requirements in light of the Supreme Court decision in Torzolari. In Torzolari, the court found that registration requirements, which can result in lifetime registration, violate the requirements of Apprehending and Leone, impose sentences in excess of the statutory maximum sentence, constitute cruel and unusual punishment, and violate the separation of powers doctrine by preventing trial courts from imposing individualized sentences. To determine whether the court erred in imposing SORNA registration requirements, the court must look to the degree which the trial court's conclusions were based upon scientific evidence. The court should consider both the defendant's evidence as well as that of the Commonwealth. In this case, the court found that the arguments were properly preserved by defense counsel, but there was no factual record. The order is therefore vacated and remanded for a hearing in which the parties can present evidence for and against the relevant constitutional and legislative determinations. And for the final case of the week, Commonwealth v. Given is a DUI case which holds that where the defendant committed a single act of driving while his blood contains both a parent compound and a metabolite of the same controlled substance, the defendant should not be subject to separate sentences for multiple convictions arising under a single section of Section 3802D1. Thank you for joining us again this week. As always, the full text of each case addressed, as well as several cases that were not covered in this week's podcast, can be found in the case notes. I hope you all had a wonderful holiday, and we wish you a very happy new year.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.